Hi, everybody. Welcome to TikTok's panel here today at CPDP, Mitigating Risks in International Data Flows, Lessons from the GDPR for AI Regulation. Thank you all for joining us. Hopefully we'll have a few others also join from outside. I know it's time for a coffee for many of us, and this is also the last panel before cocktails. So thanks all for being with us today. International data flows is something that's been sort of top of the agenda for every data protection conference that I and probably all of you have attended over the last 10 years, and it's only recently now that AI has surpassed it as the most kind of trendy topic for privacy professionals. And so today's panel brings together both topics, looking at whether we can mitigate the additional risks that AI brings in an increasingly complex and interconnected world. And maybe one thing that this panel does slightly differently to international data flows discussions is poses a potential solution, which we hope then we'll be able to discuss also with a lively Q&A. So before just I introduce my panel of experts here with me, we're going to start off with a round of kind of introductory remarks based on a question. We're then going to go into about 20-25 minutes of discussion, and then we really want to spend a lot of time answering your questions. So hopefully we'll have a lively Q&A, and please get your questions at the ready. So to introduce the brilliant panelists that I have here today, starting to my left, we have Estelle Massé, Policy Officer at the Unit for International Affairs and Data Flows in DG Just. So Estelle's unit is not only negotiating adequacy agreements and having to deal with that, but also involved in other sort of international aspects of the digital agenda, including AI. So very much looking forward to what she's going to be saying. Next, we have John Renshaw, who's the Deputy Director for Commercial Research at the NCC Group. So NCC Group, for those, some of you may be familiar, a global cybersecurity firm with certification in both the EU and the UK. And then finally, we have Jade Nestor, who's TikTok's expert for data sovereignty and data flows. Jade has a wealth of experience in the private sector as well as the public sector, having worked for the US government, during which time she was also involved in the EU-US Privacy Shield negotiations. So very delighted to have everyone here today on stage with me. And so I'll maybe kick off the panel with a question to Estelle. There's obviously a lot happening in terms of data flows. The GDPR is currently in it's turning 6 this week, and it's currently undergoing review. At the beginning of the year, we had the report on the existing adequacy decisions, and also in March, I believe it was, we also had the first sort of adequacy conference. So a lot moving in this space. So I think with that, Estelle, I'll ask you sort of how does the Commission view the current international data flows landscape, including when it comes to AI?
Thank you very much, and thank you for the invitation to speak here today. Before I touch a little bit on the landscape, I also, being aware of the title of the panel, to find some lesson learned on the GDPR, just allow me to build that landscape on the lesson learned. And I think the biggest lesson of not just the past 6 years with the GDPR, but probably the past 20 years of data protection joint work is that data is no longer seen as a commodity, but data protection is increasingly seen as a component and a differentiator between democracies and authoritarian regime. There is no longer a question so much of why or whether to protect data and to have data protection rule, but more on how to do so. And I do want to take a moment to acknowledge this reality that is fairly important as we see an increasing convergence reflected in the adoption of right-based models that are based on having data protection law, and not just data protection law, but also increasingly rules, including from places in the world where initially there is not so. I think many of you here in the room are probably quite familiar with also the recent US executive order on sensitive data, and seeing that jurisdiction, either through hard law or through other mechanisms are increasingly protecting data. Now, this is to the benefit also of data flow, creating some certainty and creating the basis, right-based rule of there is no safe data flow without data protection. And similarly, there is no safe AI without data protection. This increasing convergence that we see both in data flows and in data protection shows that data protection is not just a technical standard. It's not just about data security, that is obviously a very important component, but it's also key for effective individual rights and access to remedy. And these rights cannot be risk-based. They have to be right-based, even though the legislations, such as the GDPR, may have some aspect of risk-based, of course. Coming to the data flow component, we also see a lot of convergence in this aspect. You've already mentioned a little bit the adequacy context. And again, this is another area where we are moving away from the conversation on data flows that many of you, I'm sure, have been following for years at CPDP and other fora, where initially the question was also why is there a need to regulate data flow? Why is there a need to have safeguard in this place? To more increasing recognition that this is positive not only for data protection, but also for the market. It creates predictability, stability, and it's more a question of how to do so. Here we see a lot of benefits in having a quite vast area of tool, like we have in the EU under the GDPR. You mentioned adequacy as obviously a really important tool because it creates a really open way to exchange data, but the other tools are also extremely important for the European sector, but also increasingly at the global level. We see a high degree of convergence and work being done on developing standard contractual clause, for instance, and seeing convergence in those tools is significant for developing a common understanding of data protection, reducing in that sense risk for operator as this common understanding and convergence exists, and also creating new opportunity for us on the regulatory and executive side to find solution to bridge gap between, for instance, defunct clauses that may be similar to also help further the development of tools that facilitates data flow. We see a lot of opportunities in this area, and you also mentioned the March 4th event that was organized by Commissioner Reinders, joining for the first time the 15 countries that benefits from an EU adequacy decision. Now, this is not a small development in the sense that it's a recognition that also entering into an adequacy decision is not just a bilateral decision, but it creates a network effect that, again, can help minimize those risks and can help develop those mutual understanding for high level of data protection and those level of safety and predictability that everyone needs. So this toolbox is extremely useful once again, and we've also learned that having this toolbox and having these rules, although it may create room for a lot of question and a lot of discussion on how to exactly implement it, which are fair, and those conferences also help a lot getting through this. But to us, fundamentally, they also are a way forward to avoid having a binary approach to data protection or data flow that is not a just yes or no, you cannot do this, or here is actually the framework how to do it safely, both to the benefit of the economic actors and to ensure also the continuity of service, but the continuity of rights for citizens. Moving to how does this translate to the AI context? Now, as mentioned before, there is no AI without data. And it's, I think, quite relevant to see that also this conference has moved a lot from the core data protection conversation to a lot of the AI discussion, but it's not a different discussion. You're talking about a specific use of AI in the context of one technology. So it's really important for us to also just remind the starting point, which is also on the basis on which the EU has created its legal frameworks on AI, is that it builds on the existing framework on data protection. You have no safe AI without data protection. And so there is a need to align those models and to have them work together. And I think one of the first lesson learned, if I may draw on this, is that the AI conversation has the advantage to come after a quite healthy and developed data protection conversation that had reached the point of we should not be asking anymore, do we need to protect this? Do we need safeguards for that? But how do we make sure those safeguards are in place? How do we make sure that the right-based approach is advanced? And what is the degree where the risk management comes on top to help those? So AI, like any new technology, will bring risk and opportunity, but it has this advantage to benefit from this governance framework, not just the data protection, but also the consumer protection, the competition that they can rely on. And it's going to be very important for us to indeed see those lessons and see what has worked, what has not, but perhaps it can be a little bit faster than other conversation, taking those lessons and reaffirming also that the rights are here, and the degrees on the risk is also better and better understood when it has to be granted on those rights. Thank you.
Thanks very much, Estelle, for setting out very nicely I guess the Commission's thinking on that, and already starting with the lessons learned. Maybe I think a nice segue to John Renshaw here. I mean, I know the NCC group has recently worked on a white paper on AI, looking at some of those risks and opportunities, not only when it comes to cybersecurity, but also the broader economy. So I don't know if you can share with us some of the ideas that came out in that paper, as well as, yeah.
Yeah, sure. Thank you, Eugene. So at NCC Group, we give our consultants a lot of time to perform research across subjects that interest them. And over the past few years, obviously, machine learning and AI has been a hot topic for researchers to go and understand both how AI can be used in as a cybersecurity defender in a defensive context, how it can be used in our testing. So we go out and we test our clients' systems to understand how vulnerable they might be to different things. So how can our testers use AI to improve their efficacy, to save our clients money, to deliver better results in their testing. But then we've also been looking at how you can attack an AI model itself. What are the different ways and different opportunities to attack an AI model and the data that it's trained on. So when you think about the threat model for an AI system, there are multiple different valuable bits of data and systems that are required to deliver that functionality of an AI model. So we've looked at ways that you can poison training data, how you can extract training data from trained models, how you can extract intellectual property of the model itself, so that you can save time essentially. Without having to train your own model, you could go and steal someone else's. And then also how you can get the model to do things. And this is especially interesting in the new generative AI context of how you can get it to do things that it's maybe not desirable for it to do. And AI companies are putting guardrails around the interfaces to their models. But we find time after time that these guardrails can be subverted and got around to get the model to do things that it hasn't been designed for, or at the very least is not operating in a way that they would like the model to behave. And I think the key thing to learn from all of this research is that these are new and different risks to private data that is used to train these models, and also any data that's transferring and flowing back and forth between the users of the models and the models themselves, whether that data is being used to update the model. So you need to understand that all of these data flows are potentially risky. Whether it's the collation of training data, the training of the model itself, or whether it's the models in deployment and is serving its use case, there are still ways and new risks to that data that can be exploited by determined attackers. I don't want to say the sky's falling down. These are often quite sophisticated attacks, but the risk does exist, and you need to be aware of it. You need to understand that the data that you've used to train a model exists in some representation within that model, and so there is a risk that it can be re-extracted using clever attacks. The other thing that you can't forget with the AI models is that they are still just an application that sits on servers and uses data that's stored on hard drives and what have you, and has an API or a user interface. and you still need to address the cybersecurity of all these elements, as well as thinking about the cybersecurity of the model itself. Like you say, AI is certainly an opportunity for so many different use cases, and it can be used in positive ways and in negative ways. And what we tried to cover in the white paper was a good spectrum of how it can be used positively in the cybersecurity context, what risks you need to be aware of. We also looked at how it might enable attackers to either increase the quantity of their attacks, increase the quality of their attacks, make their attacks more successful. So there's a lot to think about in terms of the risk profile of AI in a cybersecurity context and in a data privacy and protection context.
Thanks very much, John. And I think, so turning now to Jade, I think Estelle and John have set out the context quite nicely. Maybe you can tell us a bit more about how TikTok is dealing with some of these opportunities and challenges.
Yes, so like most multinational companies, we are not unique in that we need to transfer data globally to employees globally, and then also to our other users around the world. So we need interoperability for our data to make sure that that experience works for all of our users around the world. So these are normal things other platforms and companies have dealt with before. The part that's a bit unique to TikTok, of course, is the level of scrutiny. So we have to think through, what do you need to do to comply with the law in Europe? And what can you do to move beyond that potentially? What best practices can we embed? And we've implemented a lot of these ideas into Project Clover, which is our data sovereignty program. So this reflects a 12 billion euro investment over a 10-year period. And the main tenets of Project Clover are data localization, with data stored locally by default in Ireland and Norway. And I can talk more about that later, but that's one element of this. But of course, that doesn't work alone. We're layering other things on top of that. So the next part of Project Clover is enhanced data restrictions and access controls. So this is about multi-tiered approval processes for access and really rolling back access to data, seeing who has access to what data, why do they need it, and then just limiting some people's access entirely to certain types of data based on region. The third part is third-party oversight, where we're working with NCC Group to provide oversight of the controls that we've put in place. So they're monitoring our data flows across our environment and then doing a number of other security assessments as well. And the idea here is to say, this is about accountability and it's about compliance, but also we know that there needs to be some sort of way for you not just to take our word for it, that there needs to be some other third-party element. And so that's what we're doing with this. And it's not just auditing, it's ongoing compliance, ongoing continuous assessment. So this is something that we've already started reporting on actually in our community guidelines enforcement reports. These are what we post online to talk about things like content that we're taking down. We also put a section there about security that talks about some of the vulnerabilities that NCC Group is finding and just that we're in progress for mitigating those. And we're trying to think through other ways we can be transparent about their work. But how does this apply to AI? I think taking it back to the premise of the panel, part of what we had to do was figure out what data do we have. Obviously we knew, but there needed to be this in-depth review so that we could restrict access based on the different types of data types. So we had to know who had access to what. We had to come up with different data classifications to make sure that there were certain types of data that people couldn't access. For example, employees based in China can't access certain types of data. And that was something that we were able to develop by doing this very comprehensive review of the data. And I think anyone who's trying to develop an AI program needs to look at this essential data governance question. what do you have? Who has access to it? Do they need it? You know, obviously we've had some disappointed people, including lots of Europeans who can't get into systems. You know, they can't access it, or they have to ask someone else for access to it, and it has to be subject to multi-tiered approval. I hear complaints about that just from my own team, but that's what we had to do. So it takes time. It takes a lot of resources. As I mentioned, this whole project is a 12 billion euro investment. You know, it's not insignificant. But I know that there are a lot of people at this conference in particular who are in maybe academia, or like me, you know, were in the public sector before, where I think you get an idea that companies have things much more organized than they actually are in practice. And I remember moving from the public sector to the private sector as a consultant and talking to companies and figuring out, like, they still had boxes of papers in storage units that they needed to classify. And so things were way less organized than I thought. So I think some of you might be thinking, like, well, obviously, yeah, you need to know what data you have. You need to know if it's going to go across borders. But I think in practice, there are still a lot of organizations that need to figure that out. And at the same time that they're still figuring it out and making sure that they're complying with the GDPR as a basic level, their boards are saying, you need to do AI. You need to make AI somehow, or integrate, you know, ChatGPT. And I think it's just really challenging in practice for a lot of companies. You know, taking off a TikTok hat, I think it's just a very challenging thing for companies, but the GDPR does still ground that essential practice of data governance really well, I think.
Thanks very much, Jade. So I think, you know, in our opening remarks we've heard, I think, a lot of similarity in terms of some of the concepts or ideas we have to deal with from the GDPR to AI. Heard about the risk-based approach, rights-based approach, accountability, data governance. And so those are some of the topics that we'd like to have as part of our discussion today, as well as data localization and privacy-enhancing technologies. Maybe kicking off with the risk-based approach, which has been mentioned so far. I think at the beginning of this year, there was a paper on the zero risk fallacy, and the idea that, you know, what are we talking about in terms of the level of risk that we're taking into account here? So maybe Jade, I can start with you on sort of that concept and then bring it around.
Yeah, I think those of us doing data protection for a long time have been talking about the risk-based approach for a really long time as the standard practice, and also, of course, talking about accountability as an overarching principle. And we've seen some decisions recently, which I think in that paper that Theodore Christakis wrote, he talks about some of these decisions where data controllers are asked to eliminate all risk of, for example, government access. And while I understand, you know, why there's thinking along those lines, and obviously the concern from a rights perspective, I think that there's this question of, first of all, you know, does that risk-based approach from the GDPR apply to data transfers? I think that it does. I know some people, you know, maybe disagree with that, but I think that it does. But then there's this other question of, you know, in a cybersecurity context, and I think John probably knows more about this, in a cybersecurity context, there is no such thing as no risk. You can't eliminate risk. If anyone who's working in cybersecurity tells you, I eliminated all the risk, they will be told that they are incorrect. So, you know, where do we draw the line between this idea of cybersecurity, where you should be fired if you're a CISO and you say you've eliminated all the risk, and this idea with data transfers that you have to eliminate all the risk? And again, I'm not questioning the concept of why you want to eliminate risk. It's more that I think it's very difficult for someone to very confidently tell you that they've 100% done that. So that's some of my thoughts on that.
Yeah, maybe I can turn then to you, John, on the cyber side, and maybe to elaborate on Jade's point.
Yeah, absolutely. I think you know, in cybersecurity, risk has been a big topic for quite some time now. So you'd hope that the industry is quite mature in that respect, and what Jade said was exactly right. You know, generally speaking, risk management is about identifying your risk, understanding your risk, quantifying your risk, you know, mitigating your risk, absolutely, but understanding that generally speaking, you cannot mitigate your risk away. What you usually do is you mitigate it to a level that is acceptable, and you accept that you have some residual risk. You know, you don't. If you were doing a business case for a cybersecurity investment and what you're aiming for was zero risk, you'd probably bankrupt your company, because it's in practice, broadly speaking, it is not possible. If data and systems exist, then they are potentially susceptible to cyber attacks. With the best will in the world, you can put all the best controls around it. The risk will still exist, and cyber attackers can find ways around the controls that you've implemented. Maybe you haven't implemented them correctly. What we find as independent assurers of cybersecurity systems, when we go into our clients and they say, oh, we've got all of these controls in place, and we think we're in a really good place, and a lot of the time they are, but we always find cracks, we always find things that have been missed, we always find misconfigurations, or someone's forgotten to do something, or something has changed over time and is no longer relevant, or shadow IT and all of these sorts of things where things have been implemented without an actual upfront consideration about how you might secure that data and those systems. So in the cybersecurity industry, we recognize that risk management isn't about risk elimination. It's about understanding. It's about targeted interventions, and it's about accepting what you think is a reasonable level of risk to have within your system. Now that obviously differs depending on what systems you're protecting, what data you're protecting, and that's where things like sectoral-based approaches come in, and regulation comes in. With standards like in the UK, you have Cyber Essentials, which is targeted at small, medium businesses who aren't going to have a systemic impact if their systems get compromised. It's very unfortunate and very sad when a small business does get compromised, but it's not going to have much of a bang. Probably the next step up from that in terms of information security management and risk is ISO 27001, and that, whilst it's not always implemented well and it has detractors, it's not focused on, you should implement firewalls, you should implement encryption. It does list some of those controls, and I think that's where some of the criticism comes in. But actually, the bulk of it is about establishing risk management processes, getting senior members of your organization bought into and supporting these processes, and that ISO 27001 and other standards like it are more kind of they're being incentivized through supply chains and through government mandating that their suppliers of a certain size reach these standards. And then when you get to sectors like the finance sector, healthcare, critical national infrastructure, all of these sectors, that's when we're seeing over the last 5 years, all of these regulations coming in, and a lot of them do, encourage at the very least or mandate independent testing and assurance, getting outside experts to come in to help you. It can be seen in some cases perhaps to be an adversarial relationship, but we are there coming in to help you understand your risk, to identify your risk, and ultimately to mitigate it to that acceptable level. So I think the AI Act that the EU are bringing in, and in the UK and the US, there are similar approaches of getting the fundamentals right, and in those riskier sectors where there would be a bigger impact, I think independent assurance and mandated independent assurance has a part to play.
Thanks very much, John. I think immediately 2 questions I would have for Estelle. I think one was, Jade asked it, which was, does the risk-based approach apply to data transfers? And then secondly, maybe building on John's point, we do have legislation like the DSA, which includes, again, sort of this third-party auditor concept. We do have, again, as I mentioned, financial legislation. So as part of the review process of the GDPR, to what extent could concepts like this form part of accountability?
So first, maybe because you just touched on the review of the GDPR, also clarifying that a review is not a revision of the framework. We're assessing how the framework is working, what are the areas for interesting challenges and opportunities to note, but this is not a change in the legal framework. Again, not only because the GDPR is still a tool in development, but also it's the basis for the many other legislation you've mentioned. The GDPR and its chapter on transfer and its tools on transfer are fundamentally right-based, but of course, like other aspects of the law, they are element of risk to consider indeed. But the two needs to be seen together, and when we talk also about the risk approach, we need to interrogate ourselves, which risks or whose risk are we talking about? We were discussing the company has to assess the risk and what is acceptable. Those risks has to be looked into the degree of protection also afforded into the law and the fundamental rights protected behind it and the overall system also of the market. So how does this risk respond to those rights that are being protected, those obligations that exist into that? And it's not only about the company's risk, that is obviously something to be taken into account, but it's also about the individual risk that are protected under this legislation and whose rights cannot be taken away from a risk mitigation. Now, obviously, it's through day-to-day operation, cybersecurity, and other aspects in the GDPR also very clearly into data breach consideration. There are elements of risk that are important to determine whether a higher degree of protection needs to apply to a certain category of data, whether additional data security measure needs to be in place, and how to apply this. And those will be fundamental in the AI context, the way they are and they were in the data transfer conversation. You've mentioned a little bit the work that your company has done into implementing AI. It's very similar, in fact, to the requirement under GDPR. It's looking back again what type of data you have, what type of obligation you have, and perhaps also asking back those questions. There is a rush to develop AI. AI for which reason? This is the purpose limitation. AI for which goal, and then linked to that, which data is needed that helps on this. So the concept of data minimization, purpose limitation are really guidebooks also to the AI development that gives the advantage to the company that have been operating in the European market also in a certain way to already hopefully have a fairly well organized vision of this, still developing mechanism, but that can give a pretty good advantage also into developing AI, knowing those rights and knowing also the predictability that this gives. Because again, the fact that rules exist in a system is positive for you as well as operator, because you will not wake up one day saying that on a basis of a risk, on the base of a government, you can no longer operate. Those frameworks are here to give you that predictability. Now, I'm not saying that obviously implementing those recommendations and doing this risk assessment on the basis of it is an easy task, and it's something that is going to be done in a day, but they are in the interest of the sustainability of your operation, the market operation, and also the healthiness of the digital economy that we choose. And it's really, truly a convergence that we see growing in this reality, because in a place where no rules initially potentially existed before, as soon as there were massive data breaches, as soon as there were massive abuse of data, there was the immediate reaction from people of how do you protect it and how do you do that. Now, companies that had long tradition of cybersecurity from certain sectors were maybe a little bit ahead in those points in understanding the need to do so and the need to respond. Technologies company, it's something because of your activities have been into also integrated, but I think there is still a collective effort, no matter GDPR turning 6 very soon, for us to raise awareness on this right-based approach that exists and on the risk level that applies on top of it. Indeed, that is important also for the operation and for every company to be able to tailor on top of those rights that apply across the board, how to adapt those rules and make sure that they work for you.
Thanks very much. Maybe then I can turn to one other element of the discussion that we want to have, which is localization. So I think within this legislative mandate, there's been kind of several discussions, particularly relating to cloud service providers, how much to protect the European market. Do we want physical infrastructure? Do we want data to be stored in Europe? So maybe Estelle, I can bring back to you initially, sort of in terms of the Commission's kind of international strategy. To what extent is data localization something that the European Union finds desirable or encouraging?
Coming back to the rationale of our approach in Europe about data protection, it's an approach about protecting the information and being open to data flows. And that by principles mean that data localization comes at odds with this approach of having safeguards in place for data to be able to flow and benefit from it. This is an approach that you can see translated in the trade approach also of the EU, where fundamentally what is being negotiated when there are discussion on data flows is that there are rules to prevent mandated delocalization that would cause privacy but also economic harm. And at the same time, there are rules to ensure that every party, every country can also put in place systems to protect their personal data. Now, there is an increasing demand also coming from consumers sometimes to have data located in certain jurisdiction, and you may see also for specific type of data that indeed you will see those push into some frameworks and some proposal. But fundamentally, the approach of the EU is to be open and ensure safeguards are in place and to have rules to ensure that when data can flow safely, it can do so easily. This is the EU approach, has been the EU approach for quite some time now, and it's going to continue to be it. Now, it doesn't mean that economic actors can make their own choices of where they want it to be, and it's also important for us to understand that there are many forms of data localization. Some of them are also very driven from a surveillance perspective in certain part of the world to be able to access this information. And this is why also we need to fully grasp also the full limitation that localization can sometimes have in terms of as a protection measure. It's a question of access also, as you were mentioning. So localization can be something that we see developed in framework. This has not been traditionally the EU approach, which has been more open on data flows as long as safeguards apply. But in the cases, indeed, that the question that we are been looking very much so into our own transfer, as you know, is who has access to this data, no matter where it is, who has access to this data and how to regulate that point.
Thanks. Maybe, Jade, I can bring you in here about kind of TikTok's decision to store data in Europe, as well as the kind of different protections on European user data.
Yeah, so as I mentioned, the goal is the default storage of European data in our data centers in Ireland and in Norway. The migration of European user data to Ireland has started. Norway is still needs to come online, but basically we had to build these data centers to house European data, so it takes some time. In the interim, we built a separate European enclave for European data. Now, I will say this is based as a temporary measure in the US. I know some people don't like that, but it's a capacity issue. So that's temporarily in the US. But the reason that we had to do that, the reason that we segregated that data out as early as we could while the data centers were still coming online, was because we wanted to build these security gateways around data. So it's like a technical barrier around that data to enforce the access control rules that we put in place. And so the dedicated enclave is a way for us to have that security perimeter around the data already, and already start monitoring and have NCC Group monitor the data flows in and out of that enclave to the other global TikTok data centers. So the other TikTok data centers are in Singapore and in Virginia in the US, and then in Malaysia. So those are the other three. And data would be allowed to go from this European enclave and eventually from our European data centers in Ireland and Norway if it falls into some exception categories. So by default, the data will be classified as restricted, which means that certain people are restricted from accessing it, including employees based in China, and that's things that are more of a confidential nature, in particular things like an address, IP address, a phone number if we have that, because you don't have to sign up with a phone number. So things that fall into that category, and also other different types of data, are restricted, but we have these exceptions for allowable data that can go to the global data centers, and those are things like public data. So if a user has a public video that they want other users on TikTok to see, that data needs to go to the other data centers so that people can view it globally. You know, for example, we have a lot of European, actually the most popular person on TikTok is European, Kabi Lamy is in Italy, and I think he's still the most popular creator. So we need that Italian content to go globally, right? Because he marks those videos as public. And usernames would be public, so his username is public. But if a person has a private video, so they either have a totally private account or certain videos that they want as private, that data is restricted data. That data is not going to be accessible in the same way. That's going to be limited. And so that's kind of how we're trying to divide data based on the choices that have been made about visibility. Also, data in some cases needs to flow just to ensure the interoperability of the platform. So for example, if you have a block list and you're European, that needs to be replicated across the other global data centers so that your account isn't inadvertently shown to someone who's on your block list. Also, if you are commenting on a public video, we need to be able to make that comment globally visible. So things like that that are about interoperability also can flow globally. The other data set is aggregated data, so that's more like numeric dashboards. And we're looking at things like differential privacy and other privacy-enhancing technologies to prevent any viewing of identifiable data in those cases. So there's a few different aspects of this that we're layering, but it really just depends on these categories. But that's why I said we had to do all that data governance work to figure out what we had and how to restrict it.
Thanks, Jude. And I mean, John, in some of the cyber legislation, this mandate, there have been discussions also around data localization. So I don't know if you want to say, just from your perspective, whether your clients are coming to you with questions regarding data localization and kind of how you try to bring that cyber perspective to it.
Yeah, absolutely. So I think one of the things to get across is just because you've moved your data somewhere doesn't mean that the cyber threat has gone. And I'm sure all the people in the room know that. I think, you know, I haven't really got a huge amount to add to what Estelle and Jade have just said. It's all pertinent, but I think it's really interesting that data localization is what has driven such good cyber practice in terms of classifying your data, understanding the sensitivity of your data, what controls you're putting around access to your data. You know, we're talking about those you know, role-based access controls. You know, do I need to see this data as part of my role? If I don't, then I shouldn't be allowed to see it. And then also, you know, I'm not an expert in the international arena, but the fact that certain employees in certain locations can't access certain types of data, whereas, you know, EU-based employees would be if it was pertinent to their role. And, you know, these are all good, as well as data privacy and data governance controls. They're good cybersecurity controls as well, because cybersecurity is there to protect data and to protect systems. You know, it's the wrapper that goes around these systems, and so, you know, all of these things that Jade was just talking about and Estelle were just talking about are also equally as relevant in the cybersecurity space, and whether that is an EU user's private data or whether that's the security of a water pipeline or someone's credit card information. I think these principles and fundamentals apply equally around you know, minimization and role-based access controls, and understanding where your data is, understanding where it flows, understanding who has access to it.
Thanks very much. So yeah, I mean, I think we're now coming on to the Q&A section. So I don't know if anyone has some questions. For those that do, please just raise your hand. We have a roving mic here. I would just ask you to identify your name, where you're from, and as well which speaker you'd like to address your question. Super.
Hi, I'm Anushka. I'm a lawyer working in a law firm in Brussels. I had a question regarding TikTok. So just from what you just said, I was wondering if your data governance system is able to take into account the different measures that are in place in different jurisdictions. For instance, in India, a lot of data may be categorized as obscene under the law. Are you able to distinguish between that? Because you can probably publish that data in Europe, but not in India. Like different kind of religious-related obscenity or reporting by users. Is it possible to categorize that? I was wondering.
Maybe just check if there's any other questions. Okay, we've got another one there. Maybe take 3 if there's, yeah, perfect.
Hi, thank you, Peter Swire, Georgia Tech. This is a question probably for Jade, but maybe for our cybersecurity expert also. What are the rules about having transfers of data in TikTok's system for cybersecurity purposes? So if there's malicious attackers and you recognize an IP address or a MAC address or some other sign of activity that's linked to personal data, how do you handle, are you able to flow cybersecurity helpful data, or do you have to say we can't ship it out of Europe?
Thank you very much. And I think we had one more question here towards the front. Yeah.
Thank you so much. Romain Robert from EDPS and Belgian DPA. Maybe a question for TikTok. You're talking about a risk-based approach. I would like to know, how would you define the risk? Would you think it's a risk for data subjects, a risk for business, a risk of access by other governments? Because I think there was confusion around what do we understand by risk? And second question, how would you approach that, and maybe for other panelists, this risk-based approach towards DPAs? Because for DPAs it's also quite difficult, I would say, to understand who has to define the risk and which level of risk do we accept? And maybe sub-question, is it not for the legislator to define what is the risk, acceptable risk? Don't we risk with this scattered risk-based approach to have different thresholds of risk between different DPAs and different national courts? Because we already see that national court and DPA do not agree on this risk-based approach. So what would be the best approach towards the risk-based approach? Difficult one, I guess.
Brilliant. Okay, well, I think, I guess we'll kick off with Jade first. I think a couple of questions in there regarding the different rules we have to deal with, also then sort of the data transfers of cybersecurity information, and then what we understand by this risk-based approach. And then I think maybe John, if you could address again the cybersecurity question, and then I'll bring it back to Estelle also for your comments on the risk-based approach.
Okay, so on the question about types of content, so that would be more an issue about our community guidelines, which are basically the rules of the road of TikTok. So as a baseline, we have a series of rules of what is and isn't allowed in the platform. And those are informed by our safety advisory councils, which are global. So I think there's a series of 6 of those, and they're global, and those involve people in civil society and academics and other stakeholders. And so they help advise us on what those rules are, whether they need to be updated. Of course, in certain areas there are cultural sensitivities, and we have moderators around the world, and actually in terms of our European content moderators, our local moderators, I think we have more than any other platform in Europe. I think the number is 6,000 content moderators, human content moderators in Europe, and so they are looking at content to figure out what the local context is, and if it violates those community guidelines. And then we have community guidelines enforcement reporting that we do quarterly, where you're able to see the different types of takedowns, the different types of violations. You can see how much of that was proactive, that we detected before anyone saw it. You can see basically all of our statistics for how effective our enforcement of those community guidelines is. So that's different than the Project Clover element, because Project Clover is looking at what data is this about individuals, how identifiable is it? What is the risk associated with that data? That's different, I think, than a classification of content, which would be more something that our trust and safety team looks at, which is an apparatus of about 40,000 people that deal with those trust and safety issues. So I hope that helps, but I think it is interesting for people interested in that to look through those guideline enforcement reports, because you can see all the different categories and all the different takedowns for types of content. And then I think to Peter's question about cybersecurity, so in that context, for example, for an IP address, we would say that is, yes, restricted data. So the category of restricted data in particular means that it's not accessible by any employees in China, so very specifically. So we are one of the only companies that I'm aware of that actually lists the countries where we transfer data in our privacy policy. And so the places where the destinations for other data transfers are in the privacy policy. Some of those are adequate countries, for example, like Japan, so in Korea. And so we have other destinations where we might be doing some of that work, either because the country is adequate or because of standard contractual clauses and other safeguards subject to risk assessments, et cetera, et cetera. So the restricted access, it means there's definite full country restrictions, and then everything else is just more severely restricted in terms of what the regular multi-tiered access is. And I'm sure there's some person internally who will say, Jade, you didn't describe that, but I think that's how it works. And of course, it'd be a case-by-case assessment with what kind of attack it is and what kind of information it is. But I think on the whole, these classifications that I've been talking about are pretty intact, and that we just are figuring out some way to do it globally and to have 24/7 coverage. That's the challenge, though, right? Is there anything you want to add to that?
Yeah. Just building on that, I think it really does relate to the context in which you are collecting that data and what you're using it for. So outside of TikTok and Project Clover, NCC Group has a cyber threat intelligence function. And part of what we do is we collect data on threat actors who are actively operating and trying to exploit systems. And it's a very common practice to capture information about domain names that they're using, IP addresses that they're using. These are called indicators of compromise. So you can build rules in detection systems to detect if someone's clicked a dodgy link and it's taken them to a domain name or an IP address that has been flagged as hosting malware or some other cyber threat. And so in that context, collecting that sort of data, I think is acceptable, because it's not data about personal individual people, whereas obviously in the TikTok context, a lot of the data about IP addresses and things like that is related to specific users, and so it starts to fall within that category of personal and private data, and that's where all of these controls that Jade was just talking about have to come into play. You need to, if you are using that data as part of your own internal cyber detection, then you need to apply those access controls to make sure that the people who are accessing that data are the people who are doing that job, and not just any old TikTok employee from any old location. So I think it does need to be very context aware of what you're gathering this data for, where you're gathering it from, what it represents in terms of is it related to users, or is it something that's external to your users and your systems. And I'm sure that TikTok have both of those use cases, because as well as their user data, they have to protect their own systems and make use of threat intelligence feeds, the like that the NCC Group and other plenty of other companies provide.
And
sorry, go on.
I was saying to plug, we just announced that we're going to have dedicated reports actually on like coordinated and authentic behavior and influence operations, because we used to have that in the community guidelines enforcement report, but now that will be a separate report, and that will talk about some of those investigations actually that we have to do.
Maybe coming to the third question then on the risk-based approach, how do we see it? How does TikTok see it? And then, yeah, I can bring in Estelle.
Yeah, I mean, I think there's multiple levels to it, right? Because we talk to a lot of different stakeholders about data sovereignty, and I think when you're having a conversation with a data protection authority, it's much more legalistic, and you're talking about the various cases, and as you say, conflicts between some of the, maybe not conflicts, but what it says in the GDPR, and then what the CNIL, for example, has said in some cases where they've said that you have to eliminate all risk. So there's that part of it. But then the other part of it, I think, is the conversations that we have with non-experts, where they're basically just saying, like, can anyone access your data? And it's almost like a binary question. And I think the problem with that is that we're putting together a risk mitigation program that's designed to mitigate it at a very high standard, but I think it's a difficult position to be put in to say, you know, if I'm asked yes, no, did you eliminate all risk? I don't think anyone can eliminate all risk. And what does risk mean? I think in this case they mean, can another government somehow obtain access to your data? I think with all the different breaches that we've seen recently, the answer to that for anyone is going to be no. If you're asking a binary question, can you stop a government from trying to access data, it's going to be difficult. Can you create a ton of friction for them to do it? Can you stop them from legally doing it? You know, that I think you can try to do, but I think it depends on how the question is phrased and who's asking you, which I know is kind of a circular way of doing it, but I think when I say that in particular, it's because the type of question that I get asked is almost like not the legalistic one, it's this sort of binary yes-no question, which I think is really difficult to, because I don't want to say something to someone that's not true, you know, but at the same time, I don't want to downplay all the work that we've done, for example.
Do you mind if I jump in there quickly? I do think it is a pertinent question. It's something that has been a challenge in cybersecurity for some time is risk. Risk quantification is to an extent subjective. It's, you know, there's no hard and fast science and maths behind it. It relies on the expertise of the people who carry out the risk assessments, and also who decides what level of risk is acceptable and to whom. It is a challenge. It's not one that I have an answer to, other than you need to make sure that the people who are carrying out the risk assessments are qualified and experienced and empowered to do these things. And then I think that's where you know, regulators come in to set the floor essentially and say, you know, hold on, you shouldn't be accepting risks below or above, depending on how you measure it, these levels, because you know it's you know, you're accepting too high a risk for the people that you're serving, the public.
I would echo, I think, a bit of your question indeed of having to define risk for whom and by whom, which I also don't necessarily think would lead to opposite or contrary decision, but in the context of European data protection and in the GDPR, the elements of risk are, again, very much linked to the rights and the objective of the data protection law, which is to protect this information. So the risk has to be assessed towards the data subject primarily. Now, that doesn't mean that the company cannot also assess the risk toward its infrastructure and its architecture, because if there are risks in this basis, ultimately there will be risk for data protection. So it goes in hand, and it's not, again, a binary point of here and there, but it's important, I think, to consider what is the risk also of the person who's not at the table when making those assessments, because ultimately that's who will be initially impacted by the decision, and then potentially also the company. So from what you were mentioning on looking into the different infrastructure, the cybersecurity field potentially doesn't often refer to the individuals the way data protection do, but having a safe infrastructure is in everyone's interest. So those are not conflicting points, but they're important also to just show the link in between the two. And fundamentally also the risk has been a little bit starting to be defined under data protection and under the data protection law and then by the legislators, because a data protection framework, for as much as we can see and discuss how to apply this requirement, but a data protection framework fundamentally is to allow data to be used, and saying that those are the requirements that as legislator and as democratic countries we've decided that would be safe for information to be used. And this is the level of risk, quote unquote, that is acceptable and needs to be implemented. There are additional levels to be considered into this that you've mentioned, but there is already a decision that has been made, and there is through also more guidance that needs to come from us, from the regulator, and that has come on what are the criteria to apply when you are looking into those risks, because this is really where we see all the fat is coming. There is the legislation coming from our perspective. You have to implement it to the benefit of a third party. Not everyone is at the table on all of the frame, but it has to go into the same direction, protecting the data for the person and ensuring that you have the information you need to have your continuity of service and analyze this. But I think we shouldn't oppose the risk and the right. They are working together, and also we need to see that the data subject rights is here also to enhance the risk of limiting the risk for the company. It's I think we're evolving in this situation also of not seeing rules and not seeing requirement as an impediment. We're asking how to implement them. You're giving the example in your case, which, it's really positive to see that we're moving in this direction and showing that there are multiple ways to do it, and this is why the different factors come into place, but there is a common ground on which we've agreed that there is the need to make those assessments and to think about who are we serving with those decisions.
Thanks very much. So I think we can turn back to the audience to see if there's any other questions. Particularly interested if there's questions about the AI aspect and the risks that might come in that context. So I see one question here in front of me. Yeah.
Hi, my name is Wojtek. I'm actually just curious when it comes to the Project Clover and the security enclosure. Did I correctly understood that the data that will be residing within the security enclosure is the private communication, while at the same time, if anything that is a public content that could be amplified, basically will still be remaining global?
So thank you very much. Maybe if there's any other questions in the audience? I don't see any hands up, so I think, Jade, I think that one's for you.
So the default classification for user data will be restricted data. So, and actually, let me back up. So when the data basically is leaving the app, that home destination is the European data center. So this perimeter, the security gateways are around that data center and then can enforce the rule of where it can travel after that. So the default category for the different types of data will be that they will be restricted data. So that includes the private videos, that includes private videos, but then as I mentioned, some of those more confidential types of data that are more, I won't say they are personally identifiable information, but kind of like that kind of category that's more related to an individual. That's the stuff that will likely be restricted data. There are only 3 exceptions to restricted data, so it's only these 3 other categories of restricted data which are more allowable data, and those are the public videos, as I mentioned, public usernames, the interoperability data, and then the aggregated data and dashboards. So basically, we don't want data, certain types of data, to be accessed by the employees that are based in China. So that's really the essential crux of some of this. But then, as I mentioned, some of that other data might have to flow under certain conditions to other places. But I think that's one of the big distinction things here, is that that restricted data is not accessible to those employees. In terms of the other data categories, we are trying to prevent any sort of access to that data in the raw as well, and that's why we're applying privacy-enhancing technologies to it. It's a little bit confusing, I get that, but I think, speaking of a risk-based approach, the idea here is that you have certain information that is basically accessible on the internet, and so it's harder for us to control that and say that that can't leave Europe, or that shouldn't be accessible elsewhere. But even with that, we're layering on protections. So it's a little bit confusing, but the default category is that it's restricted unless it falls into those 3 other categories. But I can talk about it afterwards as well.
So I'm hearing the bell, and I'm also hearing a lot of people excited outside, and I think getting ready for a cocktail. I know. Thank you all of those who've stayed for this interesting discussion, and for answering or asking us the panelists interesting questions. I'm going to conclude the panel by asking each of the panelists for their final thoughts on the lessons that we can learn from the GDPR for AI regulation when it comes to mitigating risks in international data flows. So, Estelle, I'll start with you.
Sure. Two lessons, perhaps. One, it's nice to not be the first comer, so you can see the experience of the GDPR, what we've learned, and put it into practice. And 2 is, again, new technology, but it's all about data, so let's go back to basics. Which data do you collect? Why do you collect it? How do you use it? Where do you transfer it? We're developing the rules. I know there are still more rules that are needed to bring clarity. We're working on it, but there is a lot of convergence for data protection that will help also reduce those risks and increase the certainty. So quite a lot to be optimistic, and quite a lot of data governance continue to be applied now for the specific context of AI, but there is no need to reinvent the wheel. Let's continue to apply it this way.
Cool. 2 very clear lessons, and enjoying the optimism. John?
Yeah, I think I want to echo Estelle's point from a few minutes ago, that I think the direction of travel is the right one, and that rights and risks should be looked at in tandem to understand how we can get better. In terms of cyber risk, I think the key thing is that it exists. You shouldn't ignore it. It's there to be understood, and it's there to be managed. And AI brings new risks, but please don't forget about the old ones as well. It is another application. It doesn't change everything else. You still have interfaces, servers, networks that it sits on top of. So you need to do both. And I think independent assurance does have a place to play in helping organizations manage their cyber risk and improve their cyber resilience.
Thanks very much, John. And Jade?
Yeah, I mean, just to echo that, I think that thinking through what accountability means, and I mean, for us, it's the third-party oversight is going to be key. And then my other plug is more for the future of privacy-enhancing technologies. I mentioned that a bit, that we're using a few with this model. But I think data flows will need to continue to solve global challenges. It's just, I think, obvious to everyone. And I think privacy-enhancing technologies will help us get to a place where you can preserve privacy and also have utility. And there's this example that NVIDIA did where they were sharing breast cancer imaging, but in a federated learning environment between hospitals in the US and Brazil, and they were able to optimize their model more with that international data without actually having to share any of that international data using this federated learning model. And that's one pilot that they did, but I think it for me really highlights the potential opportunity, and AI is a huge part of that, obviously, like in that example. So I'm excited to see what can happen, but also cognizant of the risks.
Okay, thanks very much. So, yeah, I mean, I think with that, I can just say that TikTok does have a booth. So if you have any questions about Project Clover or about TikTok generally, please come and visit the booth in the Grand Hall. And with that, thank you for your attention, your questions, and enjoy the conference and the cocktails tonight.